Hello, welcome back. So we've looked at the rules about the appointment of directors. We now need to have a look at the director's duties. So the director has some common law duties, the key one there being a general fiduciary duty which is owed to the company, and that's very like the promoter's fiduciary duty. It's a duty of good faith. Now the other duties are based on common law provisions, so they've been developed by case law, but they were codified in the 2006 Companies Act, so they're now all enshrined in the legislation. An important point where the examiner may try to pick you up is that the director's duties are owed to the company as a whole. Therefore, if anybody is going to take action, it will be in the company's name, not the name of the individual shareholders. Okay, so what are these duties? Well, there's a little mnemonic there, aspirin, to try and help you remember it. Director's duties to give you a headache. So, accountability, success, act within the powers, independent judgment, reasonable skill and care, declare an interest, and no benefits, not to accept benefits. So let's look at the first one, to act within the powers. This says that a director has to act in accordance with the company's constitution. He has to use the powers that he's been given, but only for the right purpose. And if he tries to abuse that power by using it for some collateral purpose, as it says in the notes, or some alternative purpose, then that action may well be invalid unless it's been approved by the company in general meeting. And what we'd be looking for there is an ordinary resolution, so greater than 50% of the shareholders who vote would have to vote in favour. Now, the easiest way to explain this duty is really to have a look at the following two cases. So in the Howard Smith case, the shareholders rejected a takeover bid for the company, but the directors thought they knew better. So to help this takeover bid go through, they allotted new shares to the prospective purchaser so that the shareholders in opposition wouldn't be able to reject the takeover bid. Now, they didn't do it for any terrible purpose. They really believed that this bid was good for the company. However, the shareholders in question complained to the court, and the court said that this allotment of extra shares was invalid because the directors were using their powers for a purpose that wasn't the purpose of the legislation. The power to issue new shares is to raise share capital for the company. It is not to enable them to overrule the wishes of the shareholders. Okay, so in this case, they were trying to overrule the majority of the shareholders. Therefore, the issue of shares was invalid. In Bamford and Bamford, we had a similar situation, but slightly the reverse. In this case, the company was the subject of an unwelcome takeover bid, and the directors took emergency action to try and thwart this takeover by issuing 500,000 of shares to a third party. They actually issued them to an employee benefit trust, so that trust could vote against the takeover. Now, in this case, the directors' actions were discussed at the general meeting, and the shareholders, by ordinary resolution, so 50% or greater than 50%, approved the directors' action. So in this case, the shareholders approved, and therefore the allotment of new shares was valid, even though it hadn't actually been used for the proper purpose. So you can see there that although the director's power to issue shares has a specific purpose, if the shareholders agree with the actions of the directors, then those actions will be okay. They will continue to have effect. It is worth mentioning at this point here, though, if the question that we're looking at, as in these two cases, was the issue of new shares and the way the directors have exercised that power to issue new shares, then you cannot use the votes attaching to those new shares to either approve or reject that director's actions. You'd have to exclude those and have a vote of the other shareholders. Okay, so that's the duty to act within the powers. This duty to promote the success of the company is the only one which wasn't contained in common law before the Companies Act was legislated. This particular one is a new duty, or relatively new, because obviously the Companies Act is not that new anymore. And it's meant to fit with the corporate governance regime and encourage company directors to focus on the long-term benefits of the company. And if we look at the details of this duty, you'll see what we mean. So a director has to look at what he believes would promote the success of the company as a whole, and the specific provisions he has to look at. The long-term consequences of a decision. So we're not looking at the director's next bonus period, we're looking at the long-term good of the company. The interest of the employees, the need for a good reputation and good business relations, the impact on the community, and the need to be seen to be acting fairly, particularly between the shareholders of the company. We're not really sure how the courts will interpret this duty. It hasn't really been tested properly yet, but it might be interesting to see. It is a bit of a juggling act to expect the directors to try and balance all of those interests at the same time. There will be a certain amount of compromise there. In 2.3 then, we're looking at the director's duty to exercise independent judgment. Again, this is kind of an interesting one really, because it means that a director mustn't fetter his ability to make a decision himself. For instance, by accepting bribes or by promising that if he is appointed to the board, he will always vote in favour of a particular matter. But it does mean that a director can still carry on with the normal business of the company. For instance, if the company enters into a commercial agreement that does happen to fetter the director's judgment, that's fine. If he's fettered by the company's constitution, or if maybe he's following advice from somebody else, that's all fine. Now the next duty here is quite an important one, the duty to exercise reasonable skill and care. This is the level of reasonable skill and care that will be exercised by a reasonably diligent person with. And we've got a sort of subjective-objective test here. We've got the objective bit first. The general knowledge, skill and experience you would have expect of a person carrying out these functions as director. And then a subjective bit, which is the skills of this particular director. So let's try and put a bit of flesh on that. Imagine that you are looking at a director who is running Tesco plc. You would expect such a person to have quite a lot of skill, experience, and to do a pretty good job. However, if you compare that to, say, a director of your local chip shop, possibly, it's a smaller business, you don't really expect him to have the same skill and knowledge as the directors of Tesco. However, let's imagine that the director of Tesco has resigned and decided instead to run your local chip shop. Now, in that case, you would expect that director of Tesco to use that high level of skill and knowledge that he had from his previous role. Okay, that's the subjective element of the test. Now, the director doesn't have to exercise his duty 24 hours, 7 days a week. That wouldn't be realistic. However, simply going to board meetings also isn't enough. And there is a case there of two sisters and a brother who were directors of a company. The brother had a reputation for dodgy dealings in the past, but the sisters left him to it. They let him get on with it. And as a result, he entered into huge debts, he falsified documents and letters, and generally messed things up. Now, the Court of Appeal said that the sisters should have been aware of this fraud being carried out by their brother, and as a result of their failure, their inattention to the company, they were in breach of that fiduciary duty and of their duty of care that was owed to the company, and therefore they could be held liable to contribute to the company's assets. Another duty is to avoid a conflict of interest. And again, this is a bit like the promoter's duty that we saw in an earlier chapter. So the director has to avoid being in a position where he's competing with the company. And, this sort of thing happens. Quite often, a person who is a director of one business is interested in other businesses. And it may come around that those businesses end up competing for, say, the same contract, or one business may be supplying the other. Now, to avoid this being a problem, the director can make sure that his conflict of interest is authorised by the company. And normally authorisation by the directors will be sufficient unless the articles say otherwise. In a private company, the articles could be silent and it's fine for the act to be authorised by the directors. The articles would actually have to say that authorisation by the directors is insufficient. In a public company, the emphasis is switched slightly. It's only possible for the directors to authorise a conflict of interest if the company's constitution expressly says that they can. Okay, and a bit like when we were looking at the issue of shares, if the director in question is not allowed to vote on an issue concerning the authorisation of his own conflict of interest. Now, there is a fairly recent case here that sort of tests this point. It's a slightly odd one, because in this case, a director accepted the loan of equipment from a customer. I think it was a digger, actually. It was some heavy plant that he used in his own personal capacity. And then, at some point, the customer turned around and billed the company for this use of the digger. Well, the company weren't very happy, and they sued the director for breach of his duty. And it went all the way to the Court of Appeal. And they said, well, yes, the director had obtained this advantage, this ability to use the digger, from his position as a director of the company. And that had created a potential conflict of interest because he had sort of the use of the digger on one side and the potential that the company might be charged on the other side. Therefore, it was held that he had disloyally deprived the company of an opportunity to object by failing to make a disclosure, and he was therefore liable to the company for the loss suffered. Didn't matter that he hadn't done anything dishonest. The benefit he received was actually quite small, really. And he didn't even arrange the use of the digger himself. Somebody else within the company arranged it for him. But even so, he was in breach of his duty. Okay, a duty not to accept benefits from third parties. Well, these are basically bribes. So anything that you get by reason of being a director or for making some particular act as a director, or possibly even for not doing something, for instance, for accepting a contract or maybe for not cancelling a contract, anything like that that results in a benefit accruing to the director may well breach this duty. The only defence there is that it wasn't reasonable to think that this would give rise to a conflict. Maybe the benefit was really small. Perhaps you had a lunch with a client or you were taken to a particular sporting event. The question, though, is what did it look like? It's the perception that matters. Okay, final duty here is a duty to declare an interest in a proposed transaction. So in this case, the director, as soon as he's aware that he does have an interest in a transaction, or as soon as he should be aware if it's not immediately obvious, then he needs to declare this interest. And again, it's a little bit like the duty with promoters. He has to let the company know, either at a board meeting or as a notice in writing, so basically a letter to the board, or by a general notice that's issued to the shareholders. And if he does that, we don't need approval, it's just the fact that he's disclosed it is sufficient. Then he can carry on with his proposed transaction. The only exception to that is if the company's constitution requires something more, or if the transaction trips into the substantial transaction rules, which we'll see later on, where statute requires something more to be done. Now, let's see how well that has made sense to you. Have a look at question 14, X-ray limited, and see what your view is. It's not a straightforward one, this one. It will take a little bit of thought. So pause the recording while you think about it. So in this situation, we have Javier, who is a director in Limited, and he's also a partner in the separate business. And the proposal is for a business contract to happen between Limited and the partnership. Now, it appears that the terms of this contract are just as good or even better than contracts with other suppliers, so he's not sort of trying to profit or exploit his position, but he is concerned about his position with the firm. So first thing to do is to think about which duties could be relevant here. Well, the first one is a duty to avoid a conflict of interest. But the duty to avoid a conflict of interest is expressly stated not to apply if the provisions as to disclosure have actually bitten here. Well, in this case, let's have a look at the duty of disclosure. Well, in this particular case, it would appear that Javier is clearly interested in the transaction between the partnership and limited, and therefore he must disclose his interest. So he must do this at a board meeting, would be the best thing, or possibly in writing. And in that notice, he must disclose exactly what the nature of his interest is. If he thinks it's likely that there could be other transactions with his partnership, he could make what we call a general disclosure. And in that general disclosure, he will disclose that he is a partner in the partnership and that therefore he will be interested in any future transactions with that partnership. And that way he could be protected in the future. If he fails to do this, then the contract with the partnership will be voidable. It means the company can set it aside, and it also means that he could be liable to indemnify the company for any loss. I'm going to look at the consequences of a breach of director's duties in a second. So, what happens where there's a breach of the duties? As we've already said, that duty is owed to the company, so the appropriate person to take action is the company. So, first thing would be to make good any loss that's been suffered by the company. So, that would also include accounting for any secret profits that have been made by the director of the company. Any contract entered into between the company and the director or an entity that the director is interested in could be voidable. Remember, voidable means that the contract can be set aside by the company only, because the company would be seen as the injured party here. If the director's taken property from the company, it can be taken back by the company. If appropriate, an injunction could be given to stop any breach of duty continuing. And also, it's worth noting that if there's more than one director in breach, so only the directors in breach of duty are liable here, not all of them, then the liability under there is joint and several. That means that the company can choose which director to pursue in order to recover their loss. They could pursue any one of the directors for the full amount, or they could pursue all of them together at the same time. Okay, so I think that's the end of the director's duties section. So we'll take a break there and come back and look at the next topics in a separate lecture.